For delivery of judgment, WPC 5175/19.
The matter is remanded back to the learned tribunal to give an opportunity to the petitioner to bring on record the opinion rendered in two other cases of Amjad Ali and Salim Malik. Facilitated that the writ petition is allowed by setting aside the impugned opinion. The petitioner is directed to appear within the outer limit of 6/2/2026 before the tribunal and take appropriate steps.
Obligation. For listing minute.
Yes, give it to the court master.
Wait, please, Your Lordship. I beg to mention item number 29, my lords.
9.
29, my lord. This matter will be taken after view vacation, my lord.
Okay, you have taken consider of the other
Yes,
side?
yes, my lord.
Okay.
My line is condition.
Both sides are represented on the prayer made by learned counsel for the petitioner. List after ensuing view vacation.
Yes, my lord. Obliged, Lordship.
May I present? So I beg to mention item number 34. Kindly pass over for the development and after vacation immediately.
34, you'll have to wait because this is a criminal writ petition.
Yes, ma'am.
You'll have to wait. You'll have to pass orders of looking at the record. Will you get clear when the matter is reaches?
Lordship. I beg to mention item number 11, Your Lordship. Madam, may I pass over for the day, Your Lordship?
Okay, 11 password for the DS break for violent possible.
Much obliged.
Of the respondents are represented.
Daily list item 1 for motion.
Wait, please, Your Lordship.
Yes.
Lordship, here I intend to file additional affidavit here. So I need some time to file additional affidavit.
Both sides are represented on the prayer made by learned counsel for the petitioner. Petitioner Judge John today to enable him to file an petitioner affidavit as per law. Next matter. List on give fixed date after view vacation. I'm giving a fixed date because
Yes,
this
Lord.
2019 matter.
21 January.
Duly obliged.
Item 2.
Last, which page was the order?
Abs-
In the contempt?
Yes,
Which was the
my
order?
lord, just for a moment, because it's a long judgment. Because there are certain condition which has been given last the paragraph. But I have to take your lordship why it is a contempt. Because some matters, my lord, writ petitions have been filed. In some of the cases, as your lordship is aware, writ petition has been filed also. And now, if your lordship please take to the judgment at page 22. Just your lordship has to bear it for a moment. Because normally contempt, I can directly show which part. Here, just for a moment, your lordship has to bear it for a moment. If your lordship looks into page 28, first, page 28. Lordship got it, page
Yes.
28. If your lordship goes down below, link case writ appeal 333 of 2021. And these are the petitioners, appellants before, where the appellants before the division bench. 1, 2, 3, 4, 5, 6, 7, 8. Lordship has got, if your lordship turn to page 29, there were 8 appellants. Now, appellant number 4, my lord, Mr. Our senior councilman D.K. Mishra, my lord, he was appearing in this case, but he is not a part of this contempt, my lord. Now, 6, my lord, please see 6. This is Jatindra Prasad Barua also has not filed any contempt because the writ petition has been filed by my learned friend Mr. Chaudhary. So I just want to point out. So here, meaning thereby there are 6, my lord, the petitioner before this court. Now this is 1. Now if your lordship please turn to page 62. Page 62.
Yes.
Now please see, my lord, my name appears. Writ appeal 96 of 2000, that is represented by my learned senior friend, Mr. D.K. Mishra. Writ appeal 333 of 2021, which I appeared. Now, lordship got it, my lord? 333 of 2021. Now, this is in arising out of writ petition 7122 of 2018. Arising out of, the appeal was filed, which your lordship will find a chart was given. Page 65, kindly see, my lord. 66. Page 66. These are all related to Assam Police Service, junior grade. And kindly see, my lord, serial number 32, 7122 of 2018. So these are the where the petitioner before the learned single judge. This 7122, 7122, lordship got it?
7122 was common among
What?
the appeals.
7122 was the common. Was the common against, they were the about 8 writ petitioner in 7122. So ultimately a common judgment was passed. But we came before division bench, you just recollect, it's now so many months, recollect that this was not decided by learned single judge, because when the writ petition was filed, a common judgment, then the stand which was taken by Assam Police Service is that we are all confirmed employees. Now they came up with an affidavit to nullify that particular, the notification, which was 15/9/2020, 17, where they went to nullify, and they brought 2 orders. My lord, 2 extension order, just recollect, my lord. That extension order, they want to show that there is an extension of the provision period. Now, we argued before the court, we said that that how can you bring an extension of a provision period, because this is a confirmed employee by your own notification of 15/9/2017. And we also said that these 2 notifications are not a gazette notification. If you want an extension of provision, it has to be notified. Secondly, what we argued is that you have not informed my extension of provision period to my authorities, which we have shown. You have to inform them. They could not give any reply to it. No gazette notification, they could not give any reply. That was argued before the division bench, my lord. Now, your lordship will please see the judgment now. At page 68, my lord. Few paragraphs I will show. Page 68, para 6, my lord, kindly see, my lord. Para 6, at page 68. I will not read the entire judgment. Some few paragraphs I have noted.
364.
I'm sorry, my lord. Para page 64, my lord. See para 3, my lord. I'm so sorry, my lord. Para 3, page 64. See para 3, out of remaining 47 writ appeal, it has been noted that 8 appellants has filed 2 writ petition each, which were dismissed by the said common judgment and appeal. Therefore, these 8 appellants, namely Kavita Das, Kaushik, Harshadati, Joyanta so-and-so, Jyotindra Prasad Borua, that is, my lord, my senior friend, Mr. D.K. Mishra was holding the brief. Dilip,
This is by someone else.
someone else, my lord. Dilip Kolita and Sabriya Imran. This was, my lord, my learned senior friend, Mr. Mishra, has filed 2 separate writ appeal against dismissal of one of the writ petition. But again, the second set of writ petition, they have filed a common appeal being writ appeal 33 of 2021. According 47 has been heard together. Now, if you lordship turn to page 65, from the top 1, 2, 3, 4, 5 lines. All these were done for getting the writ petition selected in the Common Entrance Exam 2013. Now, lordship, this is all these petitioners are 2013 batch and CCA 2014 batch of APSC conducted examination. In course of time, the appellant were discharged from service and they have assailed the respective discharge of filing writ petition, which were dismissed by common judgment order dated 18/3/2021, resulting this appeal. So, my lord, there was a discharge order were passed by the government. So, these two, my lord, 2013-14, they have challenged the discharge order. But we belong to 2013 batch. Now, please turn to page 68, my lord. Paragraph 6. The appellants are candidates of 2 batches of who had appeared in the combined competitive examination 2013, herein referred to as CC 2013. Now, my lord, the appellant who has cleared the C13, my lord will kindly note down thereafter 2 paragraph thereafter. The appellant who has cleared the CC 2013 were appointed in the year 2015. So, we are 2013 common ender, we are appointed in 2015. Now, please see paragraph 8, my lord. 1, 2, 3, 4, 5th line. 11 appellants are appointed in Assam Police Service, so and so, so and so. Out of this 11, 8 of 2013, 3 of 2014 batch, my lord. Now, please turn to page 69, my lord. Paragraph 10. Paragraph 10, from the bottom 1, 2, 3, 4 line above. Accordingly, by separate order, issued on different days, those 60 candidates, including the appellants, hereby were discharged from the respective service without giving them an opportunity of being heard. Said termination have been assailed by filing of 52 writ petition. That is 2013 and 14 batch. Now, my lord will kindly see at page 70, paragraph 12. It was submitted on behalf of appellant. Their services are governed by 5 different service rules. All the case ought not to have heard and decided by learned single the common judgment. So, 5 different ACS, my lord, APS, taxation, all those. Now, my lord will kindly see 75, my lord. This is where it starts, my lord. Right? 75, this is a submission before division bench. What was our submission, my lord? It has been submitted, para 25, my lord.
Related to APS?
Yes. APS, my lord, 2015, which are related to this contempt case, my lord. It has been submitted by notification dated 15/9/2017, issued in the name of Governor of Assam, by which the service of APSC, junior grade officer whose name appeared therein were regularized and given regular posting, is a proof that the provision period of those APS junior grade were completed. However, the state was spent on State respondent by filing an affidavit in opposition produced copy of two notification dated 30/12/2017, 21/2018, by which the provision period of APS, JG, junior grade and those in other alleged services purportedly extended, thereby making an attempt to override the notification dated 15/9/2017, which were expressly illegal. It has been submitted. Copy of each such notification dated 30/12/2017 and 21/2018 are shown to be sent to 17 recipients other than the concerned appellant. However, neither any appellant nor any other named authorities to whom the said notification were marked has been served with the copy of the said two notification. It was also submitted. Some of the appellant has sent RTI queries to the authorities to whom the said notification was purportedly sent, but those authorities, by the respective RTI reply, stated that they had not received the copy of the said notification, which includes, amongst other, the government press, which publishes the Assam Gazette, and the head of department under whom the appellants were serving. It has been also submitted. State has not produced a copy of Gazette where the said two notifications were published. Accordingly, it has been submitted. Said two notification were a post-dated manufactured document only to make out a case against the appellant and to prejudice the learned single judge, whereas no such notification has been issued. Accordingly, it has been submitted. Action of the state in creating a fake and manufactured document is quite questionable, which is nothing but malice in law. This was a submission before division bench in respect of this petitioner, my lord, who belongs to 2030. Now, please turn to page 81, submission by the state in paragraph 31, my lord. Paragraph 31 at page 81. Countering the general submission on behalf of the appellant, it was submitted that the first proposition of law by which he was countering those submission is that if the applicable service will provide for extension of provision, none of the appellants can claim deemed confirmation in service unless a specific order of confirmation is passed by the competent authority. In the said context, it has been submitted deeming fiction in respect of provisional is only towards extension of provision and not deemed confirmation in service. In this regard, learned senior counsel for the state has referred to provision of Rule 22 of the Assam Civil Service Rule, Rule 15 and 17 of the Assam Police Service 1961 and Rule so and so. Now, my lord will see. Now, again, please turn to page 83, my lord. 83, paragraph 35. It has been submitted that all the appellant in this batch of appeals were provisioners or temporary employees on the date when their respective discharge order were passed, issued. It has been submitted that the service rule applicable for the appellant specifically provide for provision, extension of provision, and the required of satisfaction of the competent authorities for the confirmation under the service rule. Accordingly, it has been submitted there are no legal ground for appellant to contend that the services become confirmed due to effects of time. Now, 36 miles. It has been submitted. Relevant services applicable for the appellant provide for extension of period of probation. Therefore, there cannot be implied or deemed confirmation of service. Rather, it would only mean that there was a deemed extension of the period of probation and nothing more. So now, my lord, submission of the state. Now, this is a submission of the state, my lord, which has been advanced before the court. Now, please turn to page 91, discussions and decision. 85, my lord, kindly see 85. Sorry, 85, paragraph 42, my lord. Paragraph 42, 85. It has further been submitted in connection with Appeal 11 or 2020. Kavita Das versus State of Assam, misplaced reliance is being made to notification dated 15/9/2017. By submitting that the note at the end of the said notification amounts to an order of confirmation in service, it was submitted. Said note was issued only to exempt the appellant whose name appeared in the said notification from mandatory posting in the battalion for a period of 4 months as per OM number so and so dated 30/8/2004. And moreover, it has been clarified therein that the service of those officers were urgently required in the field and in specified agencies like CID, border, so and so, due to shortage of officers. So now, if your lordship will see 100, my lord. See at page 100. 59 notification, my lord, at page 100, at page 63, kindly be looked into, my lord. See which was connected. 63. Learned Senior Counsel Appellant in Writ Appeal 196 of 2020 has referred a notification dated 15/9/2017 issued by competent authority in the name of Governor of Assam, and it was submitted. Those applicants who were in Assam Police Service junior grade were given regular posting. The note at the ending part of the said order reads as follows: above posting of so and so have completed provisional period of 2 years and are exempted from mandatory posting in battalion for period of 4 months as per OM dated 30/8/2004, as the services are urgently required in the field and special agency so and so.
This is 15 batch.
Now, this is 2015 batch, my lord. Your lordship will please mark that 2015 batch. Yes, 2015, lordship was saying DR 2015 batch. Please say 64. As there is a reference to the OM dated 30/8/2004 in the above referred notification, it is deemed appropriate to quote below the contents of the said OM dated 30/8/2004. In partial modification department OM dated 25/9/2003, the period of compulsory posting in respect of newly recruited Assam Police Service junior grade so and so after completion of prescribed provision period of 2 years is reduced from 1 year, 4 months with immediate effect. So clear cut after completion of prescribed provision period of 2 years reduced from 1 year, 4 months with immediate effect. 65. The learned senior counsel state has submitted merely because all the applicants have successfully completed a respective induction training and other training program, or they have been given second pay increment or may have been allowed to hold a regular post, would not mean that their period of provision was over. Now, my lord, 66. Though the learned senior counsel for state is disputed, appellant were still provisioned, but it is also not in dispute under a respective service rule as provisional, the appellants were entitled to only one increment. However, in their affidavit in opposition, state respondent have not specifically denied the respective appellant has received their second pay increment under they would have been entitled to only after their respective service being confirmed. It was shown on behalf of the appellant. All the appellant, while handing over their charge, described the status as ACA junior grade, APA junior grade, so and so, as the case may be. But while receiving charge, their temporary status were not mentioned. Thus, it is apparent, as per the material available on record, appellants were given regular posting. Some of the appellant has also been transferred to various departmental officers. This fact has also not been controverted. Now, 67. If the submission made on the behalf of the state is accepted while dealing with the appellant, the competent authority of the state appear to have made several common mistakes. If it can be so called so, as like granting second pay increment, which requires bill to be prepared, scrutinized by the office of AG and concerned treasury before higher pay is released. Number 2, allowing taking over charge from the appellant as provisioners, but handing over next charge to them without referring them to be provisional. 3, transferring the appellant a regular member of service to different departmental offices post. Thus, in the considered, my lord will kindly please note down, thus in the considered opinion of the court is not likely to happen unless the government was not treating the appellant as a regular member of service. It is not the projection by the state respondent. Some inadvertent mistake have happened, which is unlikely, as several officers of the approved government must have handled the service records of the appellant herein. It in the aforesaid context, now my lord, presumption, your lordship at page 68 under 114 presumption has brought that.
Next page by the state provision.
By the next page, by the state provision of law, while it can be accepted that on granting second pay increment by giving regular posting and on being transferred to departmental offices, the position of the appellant has been altered from the status of provisioner to the status of a regular employee. In the absence of any other cogent and admission material on record, it cannot be presumed that the status of the appellant remain as provisioner. Above referred point is found to have been pleaded in the writ petition referred to in the impugned judgment. However, the said point has not been determined by the learned single judge. Be that as it may, as it was submitted by learned senior counsel for state by notification issued by the competent author, provisions of the appellant may extended which is disputed by the appellant, and the same is discussed herein below. 70. It may be stated, learned senior counsel of the appellant referred to the affidavit position file on behalf of the state respondent, wherein the state respondent annexed copy of notification dated 30/12/2017 and 21/2018 to project provision period of some of the appellant were extended. It was urged annexing those notification, an attempt has been made to override the notification dated 15/9/2017, which has been claimed to expressly illegal. It may be mentioned that the contents of note appearing in notification dated 15/9/2017 has been quoted herein before. And 71, in this case, concerned appellant have been specifically pleaded in the respective writ petition, the said notification here 30/12/2017 and 21/2018 were not served on them. It was also stated, copy of the same is marked as 7 recipient other than the counsel appearing appellant. However, referring to the RTI reply received by some of the said recipient, which are available in some of the memorandum appeal, it has been successfully demonstrated by the appellant none of the other named authorities to whom have the said notification were marked has been served with copy of the said to notification. Authorities who have not received the said to notification has said notification includes the Assam Government Press, which publishes the Assam Gazette, departmental heads under whom those appellants were serving.
Concerned appellant is appellants under 330.
The now concerned appellant is your lordship will see at 71 is 333, my lord. 33. Writ appeal 333 of 2020.
Where this petition
Yes.
is where the appellant.
Now 72, my lord. No, what is that's why. Where not? It becomes very easier, but facts now your lordship is aware of it. What I am trying to make it is that by way of a notification of 15/9/2017, you have been declared as a confirmed employee. They came to the court by filing an affidavit stating that there are 2 notifications where there is an extension of provision period. We file a writ petition, my lord. It was not decided by learned single judge. Your division bench has decided it, and they confirm that these are all confirmed employees. You cannot term them as a provisional. Neither you cannot bring the theory of deem extension as a provisional. Confirmation and deem extension. They said you fall under the category of deem extension, not under category of deem confirmation. Now that was negated by the division bench, stating that no, apparently it appears that they are confirmed employees. There is a notification 15/9/2000. How can you convert back to as a provision? Reverted back as a provision. You could not have brought. That is a judgment which your lordship has passed. Now, if your lordship looks 153 kindly see. Now I'm making it short. Now 153 kindly see. Now 152 is page 140. Accordingly, appeal is partly allowed. Lordship got it.
150.
So by setting aside the impugned judgment, 152, my lord. 152, 140. Paragraph 140. Accordingly, the appeal is partly allowed by setting aside the impugned judgment order passed by learned single judge and 48 connected. The appeals are found entitled in the following relief. Right, my lord? Now please turn to 153. 1 Roman 3. The notification dated 13/12/2017 and 21/2018 are held to be expressly illegal and thus void ab initio and therefore not enforceable against the concerned appellant, so as to alter their position from a confirmed employee of the state to being reverted back to the position of provision.
The concerned appellant.
So-
the appellant
so-
is 330.
So these are, my lord, the petitioner before this court, which belong to 2013 batch, my lord. 13 batch of 2015 they appointed. So this is a direct order which has been passed. You could not have reverted back by way of that to notification. You are termed as a confirmed employee. Now, what they do it, why I have come, why there is a blatant violation of this court's order, please look into at page 157, my lord. That's why we have approached this honorable court, see 157. Now, see the order of 29th of July 2025. Your lordship judgment, please note down, 26/2025. Your judgment. See, whereas in compliance of direction at para 141 to read with para 141C, 7, passed by the Honorable Guwahati High Court dated 26, 2025 in writ appeal number so and so and other linked cases, Governor of Assam is pleased to withdraw the government order of discharging Sri Kaushik Kolita, that is the one of the petitioner, from Assam Police Service by notification dated 23/8/2018. Now, my lord, a discharge order has been passed at page 21. See page 21. This is a discharge order at page 21.
Which was certified for.
See the 21, my lord. This is a discharge order. Governor of Assam is so and so. Is with discharge Kaushik Kolita so and so under suspension. This order was set aside and quashed by division bench. Now, where is the question, my lord, to withdraw the discharge order? First, kindly see.
Is there a mistake in the order then? Page 21 is dated 30/11/18.
Yes,
If page 153, it is 30/12/17 and 20 January 18.
yeah, I'm sorry, my lord.
These were extension orders. Page
These
21.
are, no, these are all, those are extension orders. These are all 30/12.
Separate
These are separate writ petition was filed, my lord.
challenging the extension order.
We challenge the extension order, my lord. Those were extension order which was put to challenge, my lord. Am I clear, my lord? Those were the extension order which was put to challenge by way of writ petition before the learned single judge when they will file
No,
affidavit, my
That's
lord.
not the query. You see, when you are showing us page 21,
Yes,
page 21 says discharge order. This is a discharge order.
correct.
And this has been taken care of. This 30/12. This, at page 153. 413 does not appear to be a discharge order. No, this one, 140.
One,
152,
152, kindly see 152, I did trouble because 152, 140, paragraph 1, Roman 1,
Yes, not
The-
Roman one, numerical one.
numerical 1,
Yes.
sorry, numerical 1.
Discharge.
The discharge order in respect all the appellant, not you got it? I didn't. So now, my lord, will please see again at page 157.
Just a moment.
Yes.
Set aside that 21, page 21 was set aside here. And again recalled in 157. And 3 is, yeah, the concerned appellant. The concerned appellants are in data page 333. That is why you have right content.
Where is the question of not finding me as a confirmed member being declared by the High Court? No, this is not a blatant violation. It's a second paragraph.
Second does not apply in my case because it is only concerned with this post.
Second.
Oh, yes, yes.
This is not a blatant violation.
Yes. Now they have again treated me as a professional, although High Court has categorically declared that I am a confirmed employee. Declare. There is a declaration. By Roman 3, I was declared as a confirmed employee, concerned employee.
because more blatant violation in page 157, see second paragraph, more blatant. So 157 of the order, more blatant. Second paragraph, kindly see. What more, my lords? See, and whereas as directed by Honorable Guwahati High Court in case of Kaushik Kalita, who was on provision of the Assam Police at the time of discharge by notification is considered, and upon considering he is not found to fit for confirmation and being a member of Assam Police Service. How can they say? Because by paragraph 7, you all have declared as a confirmed employee. This is a blatant violation of the court's order.
Now 16B has been invoked.
And 16,
As
see next,
probationer
my
has
lord,
been discharged once
third
again.
paragraph. Now therefore, the governor is exercise of power conferred on 16B of Assam Police Service is pleased to discharge the Kaushik Kalita provisional and from service effect from 23/8/2018. That is date of discharge given, we stand substituted as directed. Where is there, my lord? Yes. Oh, yes. Correct, ma'am. No. Okay. ठीक है? Right. Right. Deeply oppressed. It has taken some time because the facts are, you have to make, that's why I thought. 3 to 7 are similar methods. 3 to 7, similar.
Same batch.
Same.
2015,
Yes, same.
Same appellants in 333. All common. Yes. Yes, on other two cases also. Same case.
All same, my lord. Separately, we have made them, we separate, because the contempt, separate. Deeply oppressed. Sorry, I have taken much more time in a contempt, but I have to. That's why I also took some time when my learned friend briefed me. I thought that I should make some marking and I should point out particular. Because there were a lot of appellants before division bench, and there is a common judgment which has been passed.
Roller coaster then.
I know, they were so difficult. Very short span the judgment was passed. It does not matter of. And so many lawyers, all different arguments. I think, my lord, I have seen my particular part, I think all the arguments has been taken back up. That's why I decided, honestly, I decided that will be a question that will be asked. I know that there was few lawyers, I think that's different opinions that they challenged by waiver writ petition. I thought that no, let me file a contempt. I thought myself, subject to the other side, what he comes and appears and point out, I think there is a blatant violation of the court's order. It's my opinion, my lord. I don't know. This is my opinion. I am saying it's a blatant violation of the court's order. Didn't, no need of going through another exercise for filing a writ petition. Now, my lord, I'll tell your lordship, now in a contempt application also, there are latest judgment of the Supreme Court where an interim order can be passed by this court. I'll show at that relevant point of time. Two orders, 2025 and 2024. There is a judgment which has been delivered by Padriwal. Because what he said, I have gone to that entire judgment. In a suit, decree is passed, execution precedent, yes, it is, decree holder is protected. But in a contempt, what happens in a writ petition? Writ petition, my lord, an order is passed, they are flouted, contempt is closed, or they may be put into the jail. That's only alternative. That's why the court now has come up that no, we should rather ancillary direction can be passed in a contempt also. This is the latest of 2025 and there is a judgment of 2024 also. Yes, kind of an injunction. Normally, I know when we used to do contempt means that you take your seat, it is between the contempt and you don't have any say. A counsel. I remember those days. Take your seat. It between us where there is a violation of the court's order. Now these things has come up now. Actually, law has changed. Yes. Deeply oppressed.
Item 8 for motion.
Oh, yes, Lordship. Yes, Lordship. So I think, Lordship, there is no case at all, Lordship.
Lord. Yes, Lord.
You have to see the implications of that act.
Yes, Lord.
The act has come, the rule has also come. Those have been published in Gazette. Now it's a those are effective. Effective.
Yes, Lordship. Mr. Payang is in consultation with the department, Lordship. Perhaps he has some more knowledge regarding that, Lordship. Lordship. Yes, Lordship. By tomorrow. Yes, Lordship. Oh. This is except separately declared for, but this is the portion he praying for bail. Yes, Lordship. Hey. Yes. Yes, Lordship.
Item 9 for motion.
But in this case, my lord, the petitioner is taken into custody. My lord, earlier also, my lord, the petitioner was taken into custody and he was kept in jail, my lord, in detention camp for 2.5 years, my lord. Thereafter, he came out, my lord, my lord,
Opinion.
my lord, impugn order. My lord, page 41, my lord.
Why should we interfere with an opinion of 2018 right now?
My lord, 2018, thereafter, he was arrested, my lord, and he came out from the jail, my lord.
Arrested
And
when?
my lord, arrested on 25/5, no, sorry, my lord, earlier arrested,
And your statements in the repetition are wrong.
my
Yeah. It appears to be wrong. Your opinion is of 23 to 2018. Correct. This
My-
is what you have challenged, page 41. I'm asking a very simple question. What is the date of the opinion?
date of the opinion is 23 to 2018, my lord.
18. Come to page 8. Line number 6. What is the date of opinion? Simple. You go to that page number 8, line number 1, 2, 3, 4, 5, 6, 7, 8. Just find out.
22, 8, 2000, my lord, there is type mistake, my lord.
Typewriter does not make a mistake.
My lord,
It's a
there is,
human error which comes in the type.
my lord, there is my mistake, my
Then,
lord.
So you have saved 1 year there.
My lord.
Okay. You are arrested when?
My lord, the petitioner could not say the exact date of arrest, but he was in detention camp, my lord, and he was released. My lord, so far the arrest is, so,
When he was arrested, when he was released,
my lord,
it was the relevant fact.
my lord, thereafter a review petition was filed by the page number 47.
Where is it?
Page 47 is a review petition for recalling the order dated 23 to 2018, my lord. And that review petition order dated page 52.
Your explanation is para 5 only, right?
My lord. There are 5 men.
In the trial, the governor did not come and depose.
Yes, my lord.
Governor did not come and
No, ma'am.
depose. Then you have no links. On merit as well as on the ground of delay. You've not been able to make out a case.
It is correct.
You have given a total different case in your review petition. Your case in the written statement were different. Your case in the review petition is totally different.
My lord, when the discrepancy of my father, my lord, came, my lord, so my lord, the review petition filed for test the DNA, my lord. My lord, actually, my father's actual name is Sahar Ali, but when Moidan Ali came, my lord, he is a father-in-law. His father was a very poor person, and he was kept in the house of Moidan Ali, and Moidan
No,
Ali
no, you
gave
see,
a.
those things doesn't, whether he was poor or rich, that is not the content, that is not the consideration in a foreigner's case. And your father can't be poor because he had 3 wives. Can't be poor. You see, if the banking would be kind of poor, I believe this. I can come up, penny with you. Save money from bank. You say. And getting there all the rights. And you find companies of the and they do not correct. But it's a good government correct. We are not the history is there from marriage. And marriage is other there before we contact. Right.
My lord, my simple and humble prayer, since he was arrested earlier also, and now he is in the custody, my lord, my lord, my lord, my lord, date, my lord, I asked repeatedly, but they have forgot, my lord. So, my lord, if the LCR, my lord, is called for, my lord, I can, my lord, on the next date also. My lord, I'll try to find out, my lord, on the, my lord, only prayer is that, my lord, lordship, since he is arrested twice, my lord, he may be allowed to, my lord, contest the case, my lord, properly, my lord, and maybe remanded, my lord. He's in the custody, my lord. My lord, I pray before lordships that, my lord, 30 days or 60 days time may be permitted, my lord, to complete the, trial, my lord. Proceeding. My lord, the ground for disbelieving, my lord, is only that the discrepancy, the name of the, father, my lord. All rational, a sense of name. My lord, the sense, my lord, the one is father and another is father-in-law. That was the, my lord, because father-in-law, because my lord, he was kept in the house of his father-in-law, and father-in-law gave her daughter. My lord, my lord, actual father Sahar Ali kept the petitioner in the house of Moidan Ali, and Moidan Ali's daughter was married later on. And when my lord, thereafter he became son-in-law. He's not the son-in-law. So, my lord, my lord, my prayer is lordship may not dismiss, my lord. Lordship, either one chance may be given to file an affidavit, my lord, by, my lord, adding the date of arrest, my lord, or my lord, my lord, my lord. Yes. My lord, may provide me, my lord, may I pray only 30 or 45 days, my lord, to complete my pleadings properly, my lord, in the tribunal, my lord. That must.
Twenty-six of the Constitution of India, the petitioner has assailed the opinion dated 23/2/2018, page 41. Passed by so and so, in case number so and so, SP inquiry number so and so, by which the petitioner, namely so and so, was declared to be a illegal migrant / foreigner of the stream of post 25K 1971, is liable to be sent back. Aggrieved by the said opinion, Next, the petitioner had filed a review petition, which was registered and numbered as review petition number 43 of 2018. The said learned tribunal by an order dated 23/7/2018 rejected the prayer made in the review petition, and resultantly the review petition was dismissed. Full stop. Next, in this writ petition, it is projected that after the impugned opinion, the petitioner was taken into custody and thereafter released on bail. And thereafter, he was once again taken into custody on 25/5/2025 and is presently lodged in Pokraja detention camp. Next. The learned counsel for the petitioner has submitted that the name of the father of the petitioner is Sahar Ali, but as he was brought up in the house of Maidan Maidan Ali, in the electoral roll of which year? In the and after attaining the age of majority, in the electoral roll, the name of his father was reflected as Noor Islam.
1989.
Where have you stated that?
My lord. Page 43, my lord, down below, my lord, third line from the bottom, my lord.
43.
Page 43, third line from the bottom. In the voter list of 1989, the name of
1989.
my lord.
It is submitted that due to ignorance, the name of the father of the petitioner could not be corrected. Steps were not taken to have the name of the father of the petitioner corrected. Accordingly, in order to prove his paternity, the petitioner in the review petition had made a prayer to have his DNA test conducted. Full stop. It is further submitted that as the petitioner was taken into custody on 2 occasions, there was inordinate delay, there was some delay in assailing the impugned opinion. Next, the maintainability of the present writ petition is questioned by the learned standing counsel for the FT matters. Next. On perusal of the documents appended to the writ petition, it is seen that in the written statement, the petitioner has clearly stated that his name was enlisted in the voters list with D mark. And that his parents had been residing in village Gorakhat, Gorakhat, under Dolgaon Police Station, under 73 number Dolgaon LAC since 1966. And that his parents had casted vote in the year 1970. And that the petitioner had casted his vote in 1997 with his wife at village Rohini Kash, ROHINIKES, under 73 number Dalgaon LAC. And that he has a certificate by the Gaonbura stating that he is the son of Sahar Ali. The oral examination of the petitioner as OPW1 was recorded on 2/2/2018. Wherein he has introduced a stepbrother, namely Abdul Magir, ABDUL, Magir, MAGIR. MAZIR. And the petitioner took a stand that his father had casted his vote in 1966. And and exhibited the voters list of 1966 as Exhibit 1. And his mother and his father and what is SM? Father and SM.
His stepmother.
Stepmother. And the father and stepmother casted vote in 1970. The voters list of 1965, you say within bracket exhibit 1, and 1970 within bracket exhibit 2. Krishna had also exhibited the NRC of his projected father as exhibit 3. Bearing image ID number 222-01418. And NRC of and another NRC of 19 of the voter year 1971. No, the vote year, VOT, vote year 1971 with image ID 222-02397 as exhibit 4. The Compra certificate dated 15 15/9/15 15/9/15 exhibit is exhibit 16. No, sorry, 6. No, not 6. Yes, exactly. Okay, after 4, it will be the NRC Seva Kendra receipt, acknowledgement of the receipt. Exhibited as exhibit 5, 6, and 7. No, 5, 6, 5, 6, 5, 6. Compra certificate is exhibit 7. And the electoral photo identity card is exhibited as exhibit 8. And affidavit regarding the correct name of his father was exhibited as exhibit 9. The projected younger brother of the petitioner was examined as exhibit as OPW 2. Named, sorry, brother namely Abdul Mazid, ABDUL Mazid, MZID. Apart from giving the names of the grandfather, mother, and stepmother, he has not disclosed the name of any other family members. And it's merely stated that that his father casted vote in the year 1966, his mother and Other casted vote in the year 1971. And his father's name is recorded in the NRC of 1966. And he is a voter of 67 Mangalday LAC. MLD is Mangalday.
No. Now it is Dolgao,
Hmm?
Dolgao LSC.
No, here it is written 67 MLD. What is, they didn't write 67 MLD. 67 MLD, LAC. And he has
MLD
a-
is my lord Mongoldoy.
I said Mangalday, you said no. You said Dolgaon. Then I said again, I wrote the same thing which is written here, MLD. Then now you say Mangalday. Be sure when you are making a statement.
My lord, MLD means Mongoldoy, my lord, but he
That's
is,
what I said, but you
Mal-
said no, this is Dolgaon.
my lord, I could not understand.
Write MLD, do whatever it is. He has a voter card. No document was exhibited by projected. What's wrong? It's not in that. No, it is saying that the Granite Tribunal by order dated opinion dated 2018. Come on. Displayed the evidence of the petitioner on the ground of the submission of the name of the father. Late, so Moidan, MOIDN, as late Sahar Ali. It was introduced in the evidence. So accordingly, comment. As there's no evidence of existence of mother and two stepmothers of the petitioner. And lack of their names in any of the voters lists. The Learned Tribunal held that the petitioner could not prove his citizenship on the basis of statement of witnesses. And the documents exhibited, and according to the petitioner was held to be a foreign offence in 1973. Next, please. Contrary to the stand taken in the written statement, in the review petition, it was reiterated, the statement of in the evidence was reiterated that the petitioner was the son of late Sahar Ali. And that at the age of 8 years, he was kept in the house of Nur Islam. No, sorry,
Moidan.
Moidan Ali, MAIDN, Moidan Ali. Thereafter, he married the daughter of Moidan Ali and continued to stay in the same house. So the petitioner has asserted that he was this legitimate son of Sahar Ali. The Learned Tribunal considered the review petition and by an order dated 23/7/2018 rejected the contention. Stop. It appears that in connection with the review petition, the petitioner had filed petition number 3691 dated 3/7/2018, conducting a DNA test of the said contention was rejected. And did not accept the contention regarding the father and the father-in-law as projected in the review petition. Accordingly, having found no merit in the review petition, the review petition was dismissed. Next. In this case, the delay in issuing the impugned opinions of more than seven years. One is just noted 23 to 18, and this repetition is filed on 17/12/2025. Just find out the 18. Full stop. The date when the petitioner was first taken into custody and the date he was released from custody have not been pleaded. And he was taken into custody again on 25/5/2025. Full stop. However, comma, in this writ petition, a plea has been taken that as the petitioner was earlier arrested and released on bail, he was under the impression that the case is disposed of and he is acquitted. Only after he was taken into custody on 25/5/2025, present writ petition has been prepared. Full stop. Next, in the opening of the court, the explanation of the delay is too vague. Stop. The petitioner, it is not the case of the petitioner that he was handed out an order of acquittal from the declaration that he is a foreigner post 25 in 1971. The petitioner was aware at the time of his arrest in the of the time when he was taken into custody for the first time, that he has been taken into custody on account of being a foreigner post 25 in 1971. Full stop. The petitioner is thus come up without selling the impugned opinion for more than 7 years. This is deemed to have accepted the opinion of the learned tribunal. Next. As the issue of citizenship has arisen in the has been is the subject matter of this petition. We have perused the materials available in the court. Just to examine it. Any case is otherwise made out. By the petitioner to show that he is a citizen of India. Is in this regard, as there is total lack of reading by the petitioner in his written statement, which is the first pleading of defense of not being a foreigner, that the petitioner has not introduced the discrepancy in the name of the father. Full stop. Only at the time of the evidence that the petitioner took up a stand that there is a substitution of his father in the voters list of 1966 and 1970s, and it is at that stage of evidence when the documents were filed, which includes the voters list of 1966 within bracket exhibit 1, voters list of 1970 within bracket exhibit 2, NRC within bracket exhibit 3 and 4, and the Gombra certificate within bracket exhibit 7. And one more, the epic within bracket exhibit 8, came the stand that his father was not the person whose name appeared as his father in the voters list of 1966 and 1970. Full stop. Therefore, the comma at the initial stage, the petitioner has failed to address the issue regarding his parentage. And only on the discrepancy or only on the substitution of the father having come to light, comma, an attempt has been made in the review petition to project that there was a error in the recording of the name of his father in the voters list. Full stop. Next, in the opinion of the court, having referred to and relied upon and exhibited the voters list of 1966 in the bracket exhibit 1, voters list of 1970 within bracket exhibit 2, NRC within bracket exhibit 3 and 4, exhibit Congress certificate is bracket exhibit 7 and the epic 8. It is not open to the petitioner to now claim in this writ petition that the entry of the father's name in the voters list of 1966 within bracket exhibit 1 and voters list of 1970 within bracket exhibit 2 was incorrect. Insofar as the name of his father appearing in the voters list of 1989 though the petitioner has Where is this 89 voters list?
My lord, that I could not annex, my lord, because that affidavit was not with the petitioner at the time of, that was submitted before the tribunal, but we could not obtain the copy, my lord. It is stated.
Okay.
So, my lord,
I
I
mentioned that the name in the voters list of 1989, which was exhibited as Exhibit 9, the name of the father of the petitioner appeared as
Maidan.
Moidan Ali. Therefore, the petitioner was aware of the names which appeared in the voters list when he had exhibited the document. And in the voters list where his name first appears is the voters list of 1989 within bracket Exhibit 9, where his father's name is different from the other documents, exhibited documents referred above. Full stop. Next paragraph. Although in connection with the review petition, the petitioner had taken a plea that his DNA test should be conducted. But under in the proceedings under the Foreigners Act and the scheme of trial under the Foreigners within bracket Tribunals bracket Order, 1964, the burden of proving that the petitioner is not a foreigner is with the petitioner. And therefore, the petitioner at his own volition could have presented any document to show his, so that who is his father and as to how it is not for the tribunal to take it upon itself to conduct a DNA test to ascertain the parentage of the petitioner. Full stop. According to Thomas, there is a discrepancy in the name of the father of the petitioner in Exhibit 9, which is the voters list of 1989, where the name of the petitioner first appears. It's not open to the petitioner to rely on the documents of any other person to claim that such other person was his father. Or that there was a mistake in the recording of name of his father in the voters list of 1989, then bracket Exhibit 9. Accordingly, court does not find any merit in the present writ petition, and therefore the writ petition is dismissed on merit as well as on the ground of inordinate delay and latches in sealing the opinion dated 23/2018 by filing this writ petition on 17/12/2025. Is that on the petition stands dismissed at the motion stage without issues of notice on the respondents. Next. The standing counsel for the FT matters shall transmit a sounded copy of this order to the concerned learned tribunal, just to make it a part of record of the proceedings of FT within bracket Roman 5 bracket close 1047 of the 2016. For future reference. You take a short break and come.
Item 10 for motion.
Yes.
My lord, the petitioner is also arrested on 25/5/2025. Earlier, he was arrested on 22/8/2000. 23/3/2020 and released on 24/3/2022. That is after 2 years, my lord. I have specifically mentioned the date of arrest and date of release, my lord. Lordship, it is on record, my lord. First of all, Lordship may kindly see page number 50. 50.
50.
This is the certificate issued by the superintendent of Central Jail Tezpur. The date of arrest and date of release is here. my lord.
It's okay, we are not disbelieving you. Once
My
you
lord.
say that, we are not.
Now,
disbelieving you.
Lordship may kindly come to page number 48, my lord, on the ground of my lord, disbelief, my lord. Page 48 of the impugn order, my lord. Page 48, exhibit 7. My lord, may I read?
Just a moment.
Exhibit 7. It is stated that the Gabra was not examined, my lord. But that is not correct, my lord. Gabra was examined as DW3. That is at page, my lord, 42, my lord. Deposition of Gabra, 42. Vernacular 43. 42, vernacular 43, my lord.
So Sharma, although there is a delay, we'll have to call the records. But Mr. A.R.D., Learned Counsel for the petitioner, as well as so and so for the respondents. We get the names, huh? Next. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has belatedly assailed the opinion dated 22/8/2019. This is page 45. Hectic matter passed by so and so in case number so and so, SP inquiry number so and so. By which the petitioner was declared to be an illegal migrant, a foreigner of the stream of post 25 in 1971. In view of the inordinate delay in sealing the impugn opinion, keeping the issue of maintainability open, issue notice returnable on, please date approximates 9th of February. Returnable on so and so. Requisite extra copies of the writ petition will be served on the runner to CGC, the state and department council within 2 days. Next. The prayer for bail shall be considered on receipt of the tribunal's records. Next. As it is contended that the petitioner has been taken into custody on 25/5/2025 and is presently lodged at
Kokra, Kokrazar.
And-
Kokrazar detention.
the holding area, holding area under 7th AP Battalion, Saraikura, Pokrajar. The petitioner, namely Nasimuddin, if not already reported, shall not be expelled from the country without any further order of the court. Next panel. Petitioner shall produce a certified copy of the order before the in charge of the holding area under 7th AP Battalion at Soraikula at CHARAIPHOI. Pokrajar, to bring the order to the notice of the said authority. List on switch.
Obligors.
Item 12.
Yeah, please, your lordship. See, as per knowledge of the petitioner, your lordship, one ex parte opinion has been passed in a FT case number 34 of 1009, your lordship, passed by Foreigners Tribunal number 2, your lordship. Now, there is no record in my hand, your lordship, regarding that opinion, your lordship. But your lordship, when one border police visited my premises only from their source in the year of 2019 only, your lordship, I got to know that one ex parte opinion has been passed against me, your lordship. Now, your lordship, we have applied certified copies of those records since 2019, your lordship. But what happened, your lordship? The officials of Foreigners Tribunal number 2 inform us, your lordship, that records are missing from their office, your lordship. One reference case number also we get, your lordship, SP reference case number 302 of 2005, your lordship. But that record is also missing from their office, your lordship. For that, your lordship, we informed the matter before the Honorable District Judge of Nagaon in the year of 2019 itself, your lordship. And we, your lordship,
But this is no one to look into this record.
lordship,
You have merely enriched the district judge's dustbin.
lordship,
District judge is no authority over foreigners tribunal.
lordship, that is true, your lordship. Otherwise,
Okay,
without-
but we'll see if they can find it out. Take it up after vacation,
lordship, yes, lordship.
but you'll have to give her
Copy, lordship,
extra copies as
Lordship.
well as soft copies.
lordship.
Is G. Bora and counsel for the petitioner and so for the respondents. The learned counsel for the petitioner has submitted that the that during police inquiry, the petitioner has come to know that there is an ex parte opinion of by the learned member from a foreigners tribunal number 2 from Nagaon in connection with FT case number 34 of 2009, arising out of SP case number 302 of 2025. In the matter of State of Assam versus matlab MATLAB, next word Dhali, DHALI. However, the petitioner, on applying for certified copies of the record was informed that the said record is not available before the said concerned tribunal. Stop recording the comma. By filing this writ petition under Article 226 of the Constitution of India, petitioner is seeking a direction for copy of the for a direction upon the authorities to provide copies of the records or to reconstruct the records and to provide relevant copies to the petitioner. Next. But one part of your prayer has to be dismissed right now.
Yes, Lordship.
That is, you want a reconstruction of the order sheet.
Lordship.
Now, please tell me if this record is lost. Who in this country would be empowered to reconstruct this record, the orders I have been passing? How can orders be reconstructed?
Lordship. Getting the-
Records can be reconstructed. Final orders, if available anywhere, can be produced. Orders cannot be reconstructed.
Lordship.
Next one. Says daily order sheets that will, presuming that the contention of the petitioner is correct, that the records are missing. In that event, would not be possible for reconstruction of daily order sheets of the record. Therefore, that part of the prayer made in the writ petition will not be considered when the matter is taken up. Next, be that as it may, the learned counsel for the petitioner shall provide extra copies of the writ petition as well as soft copy of the writ petition to Ms. A. Verma and its standing counsel for the FT and border matters, whenever that will obtain instructions. From the concerned authorities in the home and political within bracket B, bracket post department, government of Assam, as well as the office of Superintendent of Police and in bracket border, was Nagaon. As well as from the Ordinance Tribunal number 2, Nagaon. Next. The learned standing counsel for the FT matters is requested to explain requisite information. List on, this one, when? Register date.
After vacation,
Date.
end of this month, Lordship,
Register date.
Lordship, 30th Lordship.
30 January.
Yes, Lordship.
30 January 2020. But there is some urgency, it is projected here that the man is 95 years of age.
Sorry, Lordship.
The petitioner is
95.
95 years of age.
Lordship will try to get it.
But what have you been doing for so long?
Lordship, 2019,
19 we applied.
Lordship.
Now we have proposed this code in 2000.
Because the Lordship, everyone is saying that
Six-
record is,
6 years.
yes, no, record is missing, record is missing.
6 years you have been skipping.
He arrested. Is he arrested? No. No, 30 people, I guess.
Item 13.
Give you instruction, huh?
Please, Lordship. Lordship, in this case, the present petitioner has approached by challenging one notice, my lord, that was deemed to be served on 21/9/1988. I am under the IMDT Act, my lord. And the notice, though it was shown to be served, but no members of the family or the present petitioner was also not received, my lord. And in the year 2019, present petitioner was arrested and detained as about 5 years and detained in the Tezpur Central Jail. And after released, my lord, the present petitioner has approached before the honorable court for giving one opportunity to convert the IMDT case into a foreign registered a fresh case under Foreigners Act, my lord. The and in a common judgment was given, my lord, the present petitioner as well as his other family members also. But nobody was not aware about the serve of the notice. Impute notice is at page 18, my lord. And at page 21, particular seem to be noticed was received by the mother of the present petitioner. But here LTI mild. In what paragraph, your lordship? In full bench judgment, your lordship, I have annexed. Page 41, your lordship, I have annexed the judgment. Article is the relevant paragraph, your lordship, at page 63. My lord. Not fresh decision, but some references given in this my lord. My lord. My lord. My lord. My lord. My lord. But my lord. My lord. My lord. But in this case, the humble submission in this case, my lord, one opportunity may kindly grant, because already he has faced the consequences, and no body of his family members will receive the notice, and notice was served in long days back, my lord. Until and unless his arrest, they were not aware about the impute notice, and after arrested, the judgment copy was applied in the year 2022, and after thereafter, the petitioner comes to know that such incidents has happened. It is long days back, my lord. So one opportunity may kindly given you, lordship. My lord.
For the delay,
Delay, my lord, he was detained and released in the year 2024, my lord. And since he has been regularly appearing before the nearest police station, 2023, my lord. 2019, he was arrested, and 2022, he was released, my lord. At page 34, my lord. The registered book maintained by the concerned police station, my lord. And the present petitioner regularly appearing before the OC of the Nagaon police station, my lord. Till 19/5/2025, he has been appearing. And otherwise, he has no any alternative way, my lord, to contest the case at this moment. So lack of opportunity, he will be deprived his right. At least one opportunity kindly make them
He has given the
to contest the case by vacating the ex parte order.
no, you have to show us that the notice was not properly served. How are you showing us that?
My lord,
the order was passed in 1990.
my lord,
Which was scored in 2025.
my lord. But until and unless arrest, he has no any knowledge regarding the ex parte order, your lordship.
Since 2009.
1990.
Around like, so, then the rest were, beginning keep going. Get the people out.
But you have received the notice.
My lord,
You see, your fingertips is there, mother's fingertips.
mothers, your lordship, it is mothers or women normally put their signatures RTI, but here shown is LTI, your lordship.
You are challenging that now.
And there is no any date has specific date has where on which date it has served, no date has mentioned, your lordship.
asking you a question.
my lord.
It is 1.02 right now. Supposing there is some urgency, I have to leave. Your order has been dictated by now.
My lord.
This is 1.02. I have to leave because I have missed my flight. I, in front of every one of you, request my esteemed brother, put my signature because it will take her some time to type it out. Then transcribe it and give it to my esteemed brother. And in presence of all of you, I have said that my esteemed brother will sign on my behalf and I leave. Now this, admittedly, the order has the signature, has something which is a mark,
My lord.
but definitely made not by me. Or we leave out our brother, we say that my court master, he will put my initials there in the order and I leave. Now, please tell me whether that order would be illegal.
No, order is not illegal, your lord.
Why?
The notice, as per the,
Notice we'll come back to notice.
my lord.
We'll come about to the notice. But why the order passed, which does not admittedly bear my handwriting, would not be illegal. Or would be illegal according to you.
Regarding the service of the notice, this is the main issue.
Service, I'm just asking you a question, nothing to do with your, I'm in my domain. I have to go out right now. Now it's 1.05. I'm just asking, I have an urgency, I have to go. Your order has to be transcribed, signed. By the time it is transcribed, I'm already out of Guwahati. So I have requested in the presence of everyone that this is the order I have passed dictated in open court. My court master will put my signature and I leave. Query is whether the order would be valid order, it will be a wrong order, it will be an illegal order, or it will be impersonation by someone as a judge and therefore fraudulent.
My lord, the process has fulfilled by the concerned department and there is no contradictory, my lord. But one thing that as per their
But you see, your mother gave that LTI,
LTI, my lord.
correct? Now you say that for women, RTI should be made. Can we know the rule which says so?
No.
There is no rule. It is only in forms.
My lord.
For example, if you take up the, if I remember it correctly, if you take up a passport form,
My lord.
then it says for male LTI and for females RTI or something like that.
My lord.
So it is the requirement of a form that you do it.
My lord.
But in this process server's report, there is no form under the civil code rules and orders. There is no form that a process server while serving notice will take only LTI from the male or RTI from the male and vice versa from the female.
My lord.
That gender discrimination is not there.
Normally, my lord, it is the process that women's they are
No,
put
but-
their
No, don't say normally because I dislike generalization.
generally, my lord.
I dislike generalization because if I generalize, Ms. Verma would be standing up right now and saying that why you are discriminating, why I can't put my RTI, why only Mr. Sharma will put his RTI. We are living in an equal world. Please tell me which law says that in the foreigners tribunal for service, only a particular thumb impression has to be taken from the person. It's not there. Yeah. But this signature was not of A or B.
My lord.
Who will say that? That's why I put that question. Admittedly, I have not signed the order. It is being signed by my court master. It doesn't become wrong just because he has done it, because he has done it at my direction. You get a copy from the certified copy from the registry. You don't ask this whether the Mr. ABC who has signed it, whether it is your signature or not. You don't go to the copying section
my lord,
and confront this man
my,
that, well, look, this is your signature, it is your signature or not. You don't do it.
Right.
Once it is there under the seal and signature, you accept it. And there's a process service report.
my lord.
You have not.
I'm I'm not
Allegedly,
extremely contradictory, making the contradictory, my lord. So my respectful submission is that the notice was served in long days back,
continue to.
but
Continue
the
to-
family members or the present petitioner had known any knowledge, my lord.
He received
He was
notice by
arrested,
Local Board.
lordship.
Oh, no.
From 19, he has the knowledge. He was
Facts as far it is correct, your lordship, but my respectful and humble submission is that one opportunity may kindly grant, my lord. It is a precious right of the person.
already 30 years have gone.
Obliged.
13.
To be, actually, the petitioner himself is not able to provide the date, my lord. So in the year 2019, he was arrested, my lord.
19,
2019,
2019 arrested.
my lord.
Released on
Released on 2023, my lord.
Where is the statement in the writ petition about the delay?
Delay, my lords. At page, paragraph 15, my lord, at page 14. Page 14, my lord, paragraph 15.
Just.
Lord,
that no one is represented.
But
But after the order, Mr. Suleiman was here.
Yes, yes, Lord.
So we just wanted his consent so that we can record his name.
Oh,
He was here for this case only.
yes, Lordship.
Okay, then we record his name. No, not required then.
I have informed tomorrow it was speak.
No, it's okay, because we saw him sitting for quite some
Yes,
time.
yes, yes.
But at that time we were in session of a matter, we could not ask him, and therefore I suddenly, this is placed before me again. Seems like-
And
We record his presence.
yes, Lord.
My,
The explanation which you have given cannot be accepted. But this would be too vague and will be bound by our own orders in the ignorance of, ignoring the statement if we accept this contention. Now you see, in this writ petition, whatever documents of the tribunal you have annexed, all these certified copies were issued on 18/2/2022.
yes, my lord,
Correct.
my lord.
Now you say after release for 1 year, now you start, the language used here we are reading. After released, the petitioner has to undergo medical treatment and was suffering from financial hardship. Moreover, though after 1 year consulting some advocates, but not got appropriate suggestion, and now after decided to contest the case before the foreigners tribunal. That means for 1 year you were consulting lawyers. You are conscious of the fact that you have met so many lawyers, but you did not get a satisfactory reply.
Well, in lower court, actually, some advocates, he
We don't know.
consulted.
You see, we respectfully disagree with you. The reason is that we always use the word learned. In fact, despite we agree with the learned counsel or not, but we always record in our order that is learned, we had the learned counsel. So that you'll have to demonstrate that the counsel who addressed you
My lord,
was not learned.
sorry, my lord.
So you see, the problem is that you say that you have consulted many lawyers. That means you are aware that there is an opinion against you. And this opinion is dawned on you in 2019 when you were arrested. You applied for certified copies and got it on 10/18/2022.
My lord,
Now we are this writ petition was filed in 2025. Now, so therefore, you see, you are aware, even with your explanation of 1 year, you still fail because this was filed on 8 December 2025.
my lord. And after getting certified to be my lord, 6/11/2023 to
We are not on, not on your
19
statement alone. Mr. Ahmed.
19/5/2025, he was regularly appearing before the,
Mr. Ahmed, we are not on that.
my lord,
We are on the judicial principles.
my lord, my lord.
If this has to be accepted, then any explanation tendered by any person for condemnation of delay has to be accepted. Even if the delay is 10,000 days,
My
you will merely come and say that this is the order you accepted a writ petition after so many years of delay.
my
On this explanation, I have a better explanation.
but,
Because we'll, as a division bench, we are not only binding ourselves, we are also laying down a law
my lord,
for, at least for the, which will be applicable for all the judges in this court.
my,
We are not, that's why we are not finding it acceptable. It's not ignorance,
my lord.
because your claim that you are ignorant fails, because you consulted for more than a year
My lord.
with lawyers.
2-3 lawyers he was
I
consulted.
don't know, your language is that you consulted,
I'm
1 year
sorry,
you
yes.
consulted lawyers.
My lord, my lord.
Now,
I'm absolutely sorry, my
no,
lord.
not that, I'm not asking for an apology. But the problem is that once you make that statement, that means the writ petitioner must be terribly smart to consult lawyers here and there and then go ahead, take a decision. He has to be terribly smart.
Actually, proper guidance was not,
No, how do you assess?
Get
You
right.
see, you say that you are a layman. How do you assess that the counsel given by a learned advocate was not proper? To confront a lawyer's opinion, I must be knowing more than supposing I am a small, what you call, a carpenter, I am a rickshawala. If I have to take opinion of 2 or 3 lawyers and then say your counsel is not appropriate,
but
I must be very over smart.
he, when consulted to vacate the ex parte order, but the advocates, they recommended to come to Guwahati High Court, that they denied that it will not vacate in the court, same court or the tribunal, my lord. So he has not got any opportunity. Otherwise, my lord, he will try. He was tried there, my lord, but
I only have a, what you call, negative minded work. Because once you make that statement, that you consulted lawyers and you did not find their statement appropriate, means that you withheld taking action as per the advice. Whether the advice is right or wrong will depend on the result
Right.
of the steps taken.
Right.
Then you can say that I consulted A, his advice was wrong. Now I am coming to B, he gave me correct advice, I come to the High Court. You make an assessment, by making an assessment, you show that you are in fact more learned than the lawyer. I'm sorry, more learned than the learned lawyer.
my lord,
That is creating a difficulty for us. Unable to come out of that explanation.
appropriate remedy was not got. After consulting two advocates, he informed me that they were not able to give the appropriate remedy, and both the advocates were denied to take this case. Thereafter, he approached before the High Court advocates and consulted.
You see, we dealt with a matter where there is a litigation pending for 30 years.
My lord,
We had an effort undertaken in the mediation for the parties to come and settle the matter, because at 30 years, after 2 times, the matter has gone to Supreme Court, it has come back, and now it is again before the trial court.
my lord,
Made an effort for conciliation. Parties said that no, we are not interested. Whatever happens, we'll fight for next 30 years. And it's a strip of land of not more than 7 feet. They're fighting for 30 years and both sides say, their lawyers say, next 30 years also we'll fight. The appropriate solution nobody wants. We have that experience. I told you we have negative mind in work. So mediation, I participated, wanted to influence the people to have a solution. Point blank said, no, we don't want a solution, we want to fight. They led to multiple murders in the family.
Some delays there, my lord, but my respect to submission is not intentional delay because his presumption is that he is regularly appearing before the concerned police station. And he thought that that is his remedy, but thereafter comes to know that these litigations maybe create future problems. So when comes in his knowledge, he came before the honorable High Court, my lord.
Yes, Mr. Sharma.
Lordship, here in paragraph 10, Lordship, page 10, last line. The petitioner now approached before the honorable court not to arrest the petitioner on the same issue. Already he has been detained as many as 5 years in the same case and may allow to proceed him as per law. So Lordship, he is never, he already admitted that he is aware about the proceeding since 2019, Lordship. Even Lordship certified copies are obtained in the year of 2022. And Lordship, even after his knowledge also, Lordship, he is not diligent to take steps to safeguard his interest, Lordship. So, and Lordship, regarding order part, Lordship, there is no infirmity in the opinion passed by the learned tribunal. And Lordship, here we are under certiorari jurisdiction, Lordship. So,
In the impugned opinion, your lordship, there is one contradictory statement, if I may not wrong, my lord.
so Lordship, that petition may be dismissed in limine, Lordship, because Lordship, he admitted that he aware about the proceedings since 2019. Or since 2019, Lordship, even since 2022, if we from the receipt of the certified copy also, he is non take appropriate steps, Lordship, to safeguard his interest, Lordship. Only because of Lordship process of expulsion is going on, Lordship. So Lordship, he approved this honorable court.
Yes, what do you want to say?
My lord, kindly may peruse that page 30, my lord, the last portion of the impugned opinion, my lord.
Yes,
Page 30.
yes,
30, the above sentence, last part from the above sentence.
yes.
There is nothing to show that they become Indian citizens or they came over here prior to 25 March 1971. Another witness on part of the state government, another witness, Azizur Rahman, also says that the opposite parties being foreigners from Bangladesh entered India illegally. But in his statement, my lord, his own statement at page 27, kindly perused, my lord. Azizur Rahman. I am inhabitant of Blaze so and so. I know the opposite party. Wazuddin, name of the father of the present petitioner, died about 4-5 years ago. They are residing in this place for 15-16 years. In earlier time where they were lived, I do not know. They are daily wages labor. They speaking Moimonchini. On that context, the impugned judgment, it reflects that they come from Bangladesh. basing on linguistic issue, my lord.
Okay, we'll examine and pass orders. If you- In view of the several matters we have in hand, we are making it CAB.
Highly obliged, your lord.
But Mr. M.U. Ahmed, learned counsel for the petitioner. And Spencer for the respondents. The matter has been heard at the motion stage on the basis of materials available on record. Order reserved.
Item 14.
Obliged.
May I please? My lord, here in this case, my lord, I have challenged page 50 order, whereby, my lord, the application filed by the petitioner for dropping the proceeding on the ground of res judicata, because earlier he was declared for Indian. Page 50 order. Earlier order is, my lord, at page 34. I'm sorry, my lord, page 36. My lord,
Present proceeding.
notice issued, I appeared and I submitted an application.
You annexed it? No.
No, notice I have not annexed. I have annexed my application and order of rejection of the application. Page 42 is the application, my lord, that I had filed
Doesn't
before.
give the clear picture. That's why we are asking you.
Page 42 is the application. After receipt of this application, that was filed on 19/5/2025. And on that day, tribunal has called for a report from the my lord, concerned SP order. This order I have annexed page 46.
We'll have to call for both the records.
I am at this stage, my lord, paying for a similar order, your lordship, in a similar case, my lord. Yes, sir. The operative paragraph I am relying 16, 17, 18, 19 and 20, your lordship order now. Paragraph 16 to 20. Yes, I am reading.
We'll have to call for the records.
Must. In that case, my lord, it is earlier it matter was fixed on 6th. So I will pray, my lord, for
You take this on the next date, you give
Right,
us
right.
this. Heard Mr. A.I. Uddin, and counsel for the petitioner and so and so for the respondents. Next one. I think there's a repetition of the Article 26 of the Constitution of India. Petitioner, namely Abdul Hamid, has prayed for quashing of the proceedings of
FTDC, what,
FTDC 1562 of 2016. Give a dash, State of Assam versus Abdul Hamid. Is pending for disposal before the learned member, Foreigners Tribunal number 7, Tejpur, Balipara. By applying the principles of the judicature. The petitioner projects that by an opinion dated 2015, the Foreigners Tribunal first, passed by the Foreigners Tribunal first, Sonitpur, Tejpur, in page 36, in FT case number 1029 of 2012, arising out of SP case number 225 of 2010, has declared the petitioner to be not a foreign spirit. It is submitted that on an application made before the learned tribunal on 19/5/25, on the said learned tribunal
dated in 1910, page 46.
when ordered 4/10/2025 rejected the said petition, and the matter is fixed. So it is submitted that the matter is now fixed on 6,
Six, it was last, last 6/1, it was fixed,
last fixed on 6/1/2025 for written statement.
26. 6/1/2026 it was
26.
yesterday.
So it is submitted that the learned tribunal had ignored the verification report dated 19/8/2025. Sorry, 16/8/2025, which was forwarded to the learned tribunal on 19/8/2025 by the Deputy Inspector of Police within the border, Secretary for Sonitpur, State. Notice written number on so and so. Extra copies within 2 days. Call for the records of page 36 and page 36 from tribunal number so and so, and page 50 from tribunal number so and so. Next. Though the learned standing counsel for the FT matters has opposed the prayer for interim relief, as the petitioner projects that he is the same proceeding against whom opinion dated 28/7/2015 was passed. Court is inclined to stay the further proceedings of FTDC, case number FTDC 1562 of 2016. Page 50. Next one. The petitioner shall produce a certified copy of the order before the said learned tribunal to bring the order to the notice of the said learned tribunal. Next one, list on Swensson.
I am obliged.
Item 15.
May please, your lordship. Lordship, in this case,
Just-
lordship, in
Yes. Yes,
improved opinion is page 47, my lord. Opinion dated, my lord, of 23/12/2024, my lord. And my lord, you have filed the writ petition, my lord, in my lord, 31/10/2025, my lord. This is the petitioner submit the total list of 1966, 1970, 1985, 1989, all are exhibited document.
but Mr. F.A. Hassan, learned counsel for the petitioner and so for the respondents. Opinion is at page 47, dated 23/12/2024. Which the by which it is held that the petitioner has failed to establish his relationship with genuine Indian parents, and thereby failed to discharge the statutory burden under section under Citizenship Act, 1955, within bracket as amended. Further declaring the petitioner to be a foreigner of post 1971 from the specified territory, i.e., Bangladesh. Notice written within 4 weeks, extra copies within 2 days. All for the record from the following email address of the learned tribunal. Next. Period for bail is opposed by the learned standing counsel for the FT matters. Considering the prosecution made in the late petition. 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border,
Bongaigaon.
Bongaigaon. List of offences.
Obligation.
Item 16.
May please, your lordship. By way of present petition, the petitioner challenges the expiry order, lordship. That is at page 32, annex of 4. Even page 32, whereby she has been declared as foreigner post 71 stream.
Yes,
My lord,
notice pasted on the fish market. Presuming that the petitioner will go to buy fish and then say the notice there.
no,
Page 32,
yes. Mm,
both paragraph.
yes. Mm, this, But Lordship, in para 5,
This is
Lordship,
right. Petitioner will have to go to purchase fish. He can't miss this notice.
Lordship, Lordship. Kindly page 7, Lordship, para 5.
Page 7. Have to.
5, para 5. He came to know about the proceedings in the month of August 2019, Lordship.
No,
Immediately after.
we are right in presuming that you will go to fish market, you will know about the notice. No. And we have to dismiss it, we can't do anything.
So there is a delay of 6 years, Lordship.
Hmm?
There is a delay of 6 years, Lordship, but the petitioner is helpless.
I didn't get it, please repeat again. We did not catch it, please repeat again.
There is a delay of 6 years for the proceeding.
Yes. But with knowledge.
Therefore, petitioner is helpless, Lordship.
So, Gaurav, we are sorry, we have to dismiss it in view of the admission.
Yourself is admitted. Okay.
Mr. M.K. Borar from Council for the Petitioner, as well as Swenson for the respondents. Next, by filing this writ petition under Article 226 Constitution of India, the petitioner has assailed Mr. Bora, the only solution is you'll.
Yes, Lord. Yes, yes, yes. Lord.
Item 17.
May I please, Lordship. Lordship, the impugn order is at page 88, Lordship. 88.
Yeah.
Lordship. And Lordship. Hawk, Lordship.
Ninth of February.
Order the court. Next, the petitioner shall cause production of a certified copy of the order before the superintendent of police within bracket border. Morigaon, bring the order to the notice of the said authority. List on Swens.
Obliged.
Item 18th of motion.
Please, Lordship. By filing this petition, Lordship, I have challenged the impaired expert opinion, Lordship,
Each.
at page 27, Lordship. Yep. Yeah, Lordship, the petitioner never received the notice, Lordship. Because the notice was sent to a different place than the residence of the petitioner.
Okay, from where you are showing that?
Lordship, only see page 27, Lordship, address of the petitioner, Lordship. Village Lungjar,
You're reading from which page?
page 27, Lordship,
27.
impaired opinion.
Yes,
There is address of shown as village Lungjar, Lordship, but notice was sent to village Barbak, a different village, Lordship. That is a notice. It never got the notice and he has no knowledge of the proceeding and the expert opinion, Lordship. They came to know about the expert order, Lordship, only on 14/10/2025, Lordship, when police went to his has to take
Where
it
is
to
the
the
process service report? Notice of the process service report,
notice at page 23, Lordship,
3.
page 23. And 24 is the process service report, Lordship. In vernacular.
Sharma, I think that is found out. I just tell you.
You see, Mr. Sharma, in the notice, page 23,
Yes.
bottom third, you see that, John Hakim, expert.
অপরপক্ষৰ শেষ
ঠিকনাত
ঠিকনাত
noticeখন
লটকাই জাৰি
জাৰি কৰি
কৰি
প্ৰতিবেদন
প্ৰতিবেদন
দিব। প্ৰতিবেদন দিব।
দিব।
That was the instruction given.
Yes.
Correct, in the notice. And whereas in the process servers report, it stated that
গাঁও পঞ্চায়তৰ চৌহদত
upper copy to গাঁও পঞ্চায়তৰ চৌহদত লটকাই try কৰা হ'ব।
Yes. P5F is not complied with.
Interfere.
And this tribunal has also wrongly held. Was from the
Yes.
Last at this.
last.
You've seen that?
Yes, yes, Lord.
Page 20. 28, para 5, last line.
Yes,
And then not, this is a wrong finding.
yes, yes.
Third, Mr. M. Rana, then for the petitioner. And so for the respondents. By filing this writ petition under Article 226 of the Constitution of India, the petitioner namely so and so has assailed the ex parte opinion dated 1/10/2022, page 27, passed by so and so in case number so and so, reference number so and so, thereby declaring the petitioner to be a foreign 25/1971. Next paragraph. From the documents appended to the writ petition, it is observed from the process server's report, from the notice of the learned tribunal that the address of the proceeding is disclosed in the notice as village Borbakra, Barbakra, in the district of Bongaigaon. And the said notice contains directives that the two police that in the presence of two witnesses, the notice should be hanged at the last known address of the proceeding. So, however, as per the process server's report, which is a part of Annexure B to the writ petition, the report of the process server states that the notice was pasted in the Noapara, 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 Gaon Panchayat, in the premises of the Noapara Gaon Panchayat, and returned. However, the tribunal in paragraph 5 of the impugned opinion has recorded that the notice was hanged at the last residence of the proceedee. Full stop. The said observation of the learned tribunal of the notice being hanged at the last residence of the petitioner appears to be contrary to the process server's report dated 22/6/2022. So, we also take note of the fact that the learned tribunal had examined the process server on 22/8/2022, and the process and the person serving the process, namely SI within bracket border, bracket close, Ajen AJEN, Ajen Brahma has stated as follows. Page 25. Therefore, at this juncture, the court is inclined to record the note of the process server dated 22/8/2022 which is a part, a rough English translation of process service report of principal. Is given type of page 22. Therefore, it expressly appears that the evidence of the process server is contrary to the process server's report extracted herein before. Next part. Resultantly, the court is inclined to hold that the process was not really served in accordance with the provisions of order 3 within bracket 5 within bracket F of the list of the foreigners within bracket tribunals bracket order, 1964. Which requires a notice that in the absence of the proceeding, the notice be hanged at the last known residence of the petitioner of the proceeding. Next, resultantly, the ex parte opinion dated 1/10/2022, impugned in this writ petition stands vitiated owing to the non-adherence to the provision of order P within bracket 5 within bracket F of the foreigners within bracket tribunals bracket order, 1965, 64. As the process is found to have been served not at the last known address of the petitioner, provided in the notice issued by the learned tribunal. Next part. Resultantly, the said ex parte opinion at page 27 is hereby set aside. Next part. The petitioner who is duly represented by the petitioner, namely so and so, who is duly represented by his learned counsel, is directed to appear before the foreigners tribunal number 1, Bongaigaon, on or before 12/2/2026, and by producing a certified copy of the order, also file his written statement of defense and documents which intends to rely upon. Next part, it is clarified that if the event the petitioner fails to appear before the learned tribunal on the within the time allowed, it would be open to the said learned tribunal to treat the petitioner as absent on call and proceed with the matter in accordance with law.
Some time
Next
limit
one.
maybe, some time limit maybe.
So they do it, they know it. If not, it should be the state who should come here.
Okay.
You monitor it remotely.
Lot.
Next, the according to the petition has allowed at the motion stage without issuance of notice on the
Obliged.
Lordship,
I
there is
don't-
one matter, your lordship, this case, your lordship, item number 28, this is an detention under NSA has been put to challenge, your lordship. Your lordship, in this case, government has not filed any affidavit till date, your lordship. No, and one more aspect is there, your lordship. Today,
We can't avoid today.
no, your lordship
We'll
is not
fix it day after-
required,
We'll fix it day after tomorrow.
lordship, lordship.
Lordship, my matter will also be fixed day after tomorrow.
Because-
Then habeas corpus one, my
Because-
son when he's
because purpose matters.
36,
Lordship-
item number 36.
Lordship, in 21, item 28, I will file affidavit. I have received instruction yesterday. So some,
But still, if it's NSA detention, we have to list it. You make a prayer, if you can't file it within 2 days, you make a prayer on that day.
Lordship.
We can't, these things can't be postponed.
please, my lord, 1 week,
Hmm?
after review vacation, you will receive the case.
The NSA matters, detention matters, we can't adjourn it like that. If it
Lord.
come, then we'll see.
Lordship.
Make a
Lift your-
prayer that day.
Yeah, please.